It's my understanding these people are willing to let me do my 15-minute presentation.
Just clap your hands if you're giving up your time.
Thank you. As I said, my name's Andy Schneider. I'm an attorney. I've lived in Malvern Hunt for 20 years. For the last month or so, I have spent every spare minute reading the municipality's planning code, case law, deeds, property transfers, easements, environmental covenants, and transcripts from quasi-judicial proceedings. I was all set to give you a legal explanation as to how and why you will be committing a legal error if you approve this plan. But after I attended the last Board of Supervisors meeting last week, it dawned on me that anything I say about the law, you're just going to defer to the various solicitors the township may employ. A solicitor from 2018, President Clumpini excluded, is a big part of the problem we're having right now. In recent meetings and reading transcripts, emails, and text messages that people have received from right to know requests, you can see some of our township solicitors spoon-feeding their witnesses and carrying their water. Not you, not Ms. Kearney or Mr. Crotty. Take a look at slide 2. This is from a 2018 zoning hearing that kicked off this 8-year run of things. This slide is one of our lay people, zoning board officer neighbors, doing his darndest.
Mr. Schneider, we really can't see it. Do you have handouts? Yes, I understand that, but we're looking forward and we can't see it on that.
I can mail it, email it to you. Yeah. I mean, were you able to see theirs?
Oh, you're good.
So what you see up there is a zoning hearing officer saying that the variance doesn't meet the standards of the law. He knew in the moment that the application, their predecessors in 2018, did not demonstrate substantial, serious, and compelling reasons for the variance. The zoning officer knew in the moment. But if you move to the next slide of that transcript, you have the township solicitor telling him that he can ignore the law because nobody is here to object. That transcript, you can ask your counsel, is what's going to help us win that land use appeal. More recently, one of our solicitors stood up at a meeting and scolded us and said the developer has vested rights. Now, you heard Mr. Wall, also an attorney and a law professor. He explained a little bit more about vested rights, and I sent a letter about that. But I haven't heard back in writing from our lawyers. I would think if there was a rationale supporting that vested right arguments, they could provide it to me. The following is not an insult, it is an element for the record. The Sentinel team is not acting in good faith. And an easy example of that happened at the last meeting. We had some really smart people talking about the sound problems this data center will cause. They had honest, legitimate, fact-based questions. The developer's attorney got up and said, there's a 30-day prison sentence if they violate the noise ordinance. Really? First of all, corporations don't go to prison. And second of all, that can only happen if they don't pay the fine. And that was the exact point of the commentator, that the Wall Street billionaire investors will do whatever is cheaper, pay the very, very modest fine or spend the millions to come into compliance, and do the math. Also at the last hearing, Sentinel was asked another very valid and important question about the chemicals that will be used or emanating from a bunch of massive air chillers. Rather than just simply tell us the name, they said, don't worry, it's non-hazardous. Only after some pushback by Senator Muth, who is behind me, did we hear that one of the chemicals is R513A. Why did it take that pushback from our senator? Get that answer? Probably because they didn't want us to use the Google machine and see what that says. Per Google, the hazardous characteristics are, in fact, low toxicity. But low toxicity is not non-hazardous. The physical hazards include liquefied gas under pressure. It's an asphyxiant, can cause burns, cardiac effects, inhalation problems. I believe Mr. Rubino likened it to a supermarket cooling system. Their data center clients will be happy to know that I have the paid version of ChatGPT. And it tells me, and I quote, "This is a really good and important question because the scale difference is enormous and often misunderstood in hearings." Gentlemen, when a developer comes into East Whiteland Township looking to develop a massive project while giving less than candid answers in the planning process, what kind of candor can you expect once they have their roots in our soil? We, the people in this audience, are your friends and neighbors. Stand with us. And if they threaten you or otherwise bully you, we will have your back. In Great Valley School District, we teach our kids to stand up to bullies, to not be bystanders. And that's what this amazing group behind me is doing. We are standing up for you and for ourselves. For the last month or so, I was very frustrated as I went through so many documents that have been revealed, the right to know requests. One thing's clear, there have been many failures within our government that have gotten us to where we are. But you know what? I'm the government. You guys are the government. We are all the government. And good governance requires vigilance and participation. We have failed ourselves to this point, but we can fix it. Tonight, with no votes from you, or in court. I'm not here to fight with the three of you. I've not seen any of your names on the overt mistakes of the past. Tonight, I'm here to push back against the developers who thought they could just come in here, fill out some paperwork, get approvals, and do whatever they want. I'm here to show you exactly why you need to stop listening to whoever is telling you that you need to approve this plan or that the old plan is viable. This development plan started out as a very small, locally funded data project. In 2018, a company named Whiteland Holdings went in front of our zoning hearing board and asked for a variance to build a data center on their property. That property can be seen on slide 4. As you can see, just above the yellow highlighted area is Malvern Hunt, which has 279 homes, and Malvern Crossing, which has 60 homes. That yellow property used to be parcel number UPI 42-3130. At that zoning hearing board, Whiteland Holdings asked the zoning board for permission to build a data center on 44 of those 72 acres. Next slide, please. Next slide, please. The applicant called witnesses to testify as an expert. And you can see right up there, 44 acres, including the eastern section. If you can turn to the next page. And there's the question. From the same firm as Mr. Robinson, there he is. He's saying sufficient to accommodate the data center on 44 acres. And that variance was granted by way of order dated 2/26/18. Next slide, please. Again, 44 acres of their 70. 3 months after that, if you turn to the next slide, please. The lawyer for Sentinel, his predecessor, not Sentinel, their predecessor, emailed a township solicitor asking to amend a portion of the ruling on that variance. They wanted to make clear that the data center was to be built on the center blue parcel, and that the red parcel was for the solar field, and the green parcel was reserved for future development. And so the zoning board agreed to make even clearer what the data center was for, and they approved that for future development. Then at some point in the following year, 2019, that large yellow property was formally subdivided, as you can see in slide 9. That red section is 11 acres, the blue section is 33, the green section is 28, all plus or minus. But they didn't just ask for any 44 acres, they were very specific. They said, including the eastern sector of the property. Next slide, please. The red is 11 acres, and the blue is 33, which is where you get the 44. That eastern sector is the red section. If you note, it has a very interesting shape. That shape was formed because that was the section of the EPA Superfund site, which the EPA has defined as the quarry. Those 11 acres are where the toxins of the Superfund are buried. Since they cannot dig on that property, they plan to build a solar field there to provide electricity for their data center. And the plan was to build 2 buildings on the other 33 acres, which you can see in slide 11. And the oval in the sketch was to be reserved for future development, as requested. So there you have it. In 2018, they asked for permission to build a data center on 44 acres, and the zoning board approved it. Slide 12. At some point after that, the property was bought by Green Fig Land. In 2021, Green Fig Land went in front of the zoning hearing board and asked for some more variances. Again, unfortunately, the zoning hearing board granted more variances like they were giving out candy, despite the legal requirements that their own zoning hearing board cites. They noted, the reasons for granting a variance must be substantial, serious, and compelling. A party seeking a variance bears the burden of proving that unnecessary hardship will result in the variance is denied, and the proposed use will not be contrary to the public interest. Despite that tough burden, more variances were granted. Those variances were outlined in a letter by the township solicitor in the next slide. That's a 4-page letter from November 16, 2021. And nowhere in that document are they granted permission to go beyond the 44 acres permitted in the 2018 variance. Now, if you turn to the next slide at the bottom of the page, into page 2, variance is granted for a data center to allow additional building square footage for a new total of 1.86 million square feet. More building square footage does not mean more acreage. There's nothing in that variance that allows them to build beyond the 44 acres. If you turn to the next slide, March 25th, I sent a letter to the township solicitors explaining this, and I asked them to do their due diligence. Sunday evening, I was informed that this would be reviewed with you. Moving to 2024, the property is still owned by Green Fig, and at some point they had submitted whatever was needed to get to the next stage in the process. So they received the approval of their final plans to build a data center, slide 16. Now here's where the term vested rights comes into play that Professor Wall expressed. He and I agree on that. Any suggestion that Sentinel has unfettered vested rights is legally incorrect. And on March 31st, 2026, slide 17, I sent a 5-page letter brief to 2 of the township solicitors outlining my legal position on vested rights. I asked them to provide written responses by April 12th. One of the solicitors sent a letter saying it was not their domain, and I did not receive a written response as requested from the other, but I was told that it would be reviewed with you. If for some reason your solicitors are still going to insist that Sentinel has vested rights, they have to admit that those rights are not without limits. Sentinel can't just do whatever they want on that property just because they may have certain rights, can they? The 2024 approval was not carte blanche. They were not given permission to do whatever they pleased. Yes, they did get approval, but there was so much more to it. If you turn to the next slide, you can see the final approval was given and was approved with conditions. And approved with conditions is what's going to win the day for us. We, the people of East Whiteland, were willing to let them build a data center here with conditions. They expressly agreed to those conditions, yet they have not met those conditions, and they cannot meet those conditions, and it is clear as can be. The condition that I will focus on is condition P, which can be found on page 5 of the 2024 approval, slide 19. It says, the applicant shall comply with the decisions of the East Whiteland Township Zoning Hearing Board from 2018 and 2021. So let's go back to see what it says in 2018 on slide 20. At the top, you have the language granting the variance to build a data center on 44 acres. On the left, you see their 44-acre plan. On the right, you see the latest amended plan that is before you. If you recall, they went out of their way in 2018 to amend the variance decision 3 months after the fact to make sure they noted that the data center was to be built on the 44 acres Yet somehow they dropped a massive building on that future place for future development without any approval from the township. The amended plan does not meet the conditions that they agreed to, and these plans must be rejected. There's more. There's more, and it's really easy. It's so basic. Let's look at slide 21, the variance that says they must comply with. It says, the proposed use and intensity thereof shall be consistent with the applicant's plans, testimony, and evidence presented at the hearing. So what was their testimony? That they must comply with. Let me turn to slide 22. In their efforts to get the 2020 variance, Mr. Ledane said, so we're putting an entrance on the Sweetsford Road, and we're not going to complete that entrance until after the construction, well, late in the construction, because we're going to bring everybody in for the construction through the back entrance, which is through Pico, right off 202. Mr. Ledane went on to explain the entrances in more detail, details that they must comply with because they agreed to comply with them. Slide 23. He said there'll be 4 entrances. They can come in through Valley Creek, and it can come in through Backton Hill Road, and that's on our 4th entrance is from the bottom coming up. So we have 4 entrances coming in there. Probably not a lot of that traffic is going to come in there. Most of it is going to come in off of Valley Hill, and there could be 20 people working on a shift. So the traffic is only going to be a concern during the construction period. We're going to bring the construction traffic in from off of Route 30 and 202. Their amended plan only has 2 entrances, not the 4 that were required and promised, as you can see on slide 24. The green stars mark the Backton Hill Road entrance, which is the only one that exists, and the yet-to-be-built Sweetsford Road entrance. The red stars mark the areas where they promised entrances, but they do not exist. And at the latest hearing, the gentleman over there talked about the Valley Creek entrance, but they never got approval for that. So why are we still here? The plans do not match their testimony. They have not met the conditions of approval. You must reject the plans. There's some more testimony about a condition of approval that has not been satisfied, and this one's a monster. This also comes from Mr. Ledane's testimony at the 2021 hearing board. Again, this was something that was required. They agreed to satisfy. It's unfortunate for them, but it was not optional. They didn't get to call an audible, as they appear to have done. The next slide shows an exchange between a zoning board officer and Mr. Ledane from the 2021 hearing transcript. Could you move that, Brittany? And this is the zoning officer telling them what their requirements are. The applicant shall, and Ms. Kearney can tell you that's not optional in the law, it's a requirement, shall obtain a letter from PICO indicating that the existing electric substation will be sufficient to provide power to the proposed facility without any adverse impact on any other areas serviced by the station. Mr. Ledane said that's correct, and the zoning officer was asking him, you're in agreement with that? And Mr. Ledane said, yes, I am. There is another massive condition that has not been yet met. Last meeting I heard from someone from Sentinel talk about funding and or plans to upscale the PICO substation. And that's all fine if they decide to try again once they face an appropriate ordinance. But the condition that was placed on them, and they agreed to, was they needed a letter from PICO that the existing substation will be sufficient. The amended plans were submitted in December of 2025. I have not seen such a letter, and I'm highly certain that it does not exist. It seems that Sentinel has its own plans without regard for the conditions that each Whiteland Township placed on their approval, and they agreed to. If you look at slide 26, you can take a look at their plans. And when you zoom in on their plans, you can see they have planned their own substation. If the PICO substation has enough power, they don't need their own. They never had any intention of complying with the terms of the variances because they assumed nobody would be paying attention. And by the time they started moving earth, nobody would even notice. And certainly nobody would have the resources to hold them accountable, not even East Whiteland Township. To summarize, East Whiteland Township gave approval to Sentinel's 2024 plans with conditions. The three ginormous conditions that have not been met and cannot be met can be seen on the final slide. The amended plan violates the 44-acre restriction. The amended plans do not have the 4 required entrances, and they do not have a letter from PECO that their existing substation will be able to service their facility without affecting the rest of us. If, for some incomprehensible reason, this has not convinced you gentlemen to put an end to this, I respectfully request you spend a few hundred of the taxpayer dollars for an independent legal opinion